Hello everyone, I believe you must remember that in my previous video I have discussed the theories of divorce and then I promised that in my next or the part 2 video I'll be discussing the legal proceedings of divorce law, specifically the section 13 of the Hindu Marriage Act 1955. So I'm here to complete my promise. So let's discuss the section 13 of the act. As discussed above, section 13 of the Hindu Marriage Act, it discusses the provisions of divorce, and for the clear explanation, it is categorized as the first, section 13 clause 1, it defines the grounds of divorce. Section 13 clause 2, it provides separate grounds for divorce by way of protective discrimination in the favor of wife. Section 13a, it defines alternate relief in divorce proceedings, which is nothing other than the explanation of judicial separation that I've already discussed in my previous video while discussing the section 10 of the act. And the last one is section 13b, it defines the divorce with mutual consent. Now let's discuss the section 13 clause 1, which defines the grounds of divorce in brief. The first ground is adultery. Adultery means the consensual and voluntary intercourse between a married person with another person, married or unmarried, of the opposite sex. It means that either party, after solemnization of marriage, had voluntary sexual intercourse with any person other than his or her spouse. But I would like to grab your attention on the important amendment regarding adultery. Adultery, which is used to be a criminal offence under section 497 of Indian Penal Code, is no more a criminal offence, but still adultery is a valid ground for divorce. On 27th of September 2018, the Supreme Court of India, in the case of Joseph Shine versus Union of India, decriminalized the adultery. Adultery within the ambit of matrimonial relationships has always been a ground for divorce. A divorce petition can be filed by the aggrieved spouse in the court of law to obtain a decree of divorce on the grounds of adultery. So now we'll move towards the second ground, which is cruelty. See, there is no precise definition for cruelty under Hindu Marriage Act. Cruelty as a ground of divorce, it includes both physical cruelty as well as the mental harassment. Physical cruelty can be established by wounds and corresponding medical reports, but it is very difficult to prove the mental cruelty. Third ground is the desertion. Desertion means the rejection by one party of all the obligations of marriage. It is permanent abandonment of one spouse by the other spouse without any reasonable justification and without his or her consent. In short, it is a total repudiation of a marital obligations. The fourth ground is conversion. When a person changes his or her relation by formally converting into the new religion, and he or she ceases to be the follower of his former faith and becomes the follower of the new faith without the consent of the other spouse, then the aggrieved spouse can approach the court and seek the remedy of divorce. Now moving towards the fifth ground under which divorce petition can be filed is insanity. Insanity means when the person is of unsound mind. Insanity as a ground of divorce, it has following two requirements. The first requirement, the respondent has been incurably of unsound mind. The second requirement, the respondent has been suffering continuously from mental disorder of such a kind and to such an extent that the petitioner cannot reasonably be expected to live with the respondent. Sixth ground of divorce is venereal disease. If the other party has been suffering from venereal disease in a communicable form, is a valid ground for divorce. The ground is made out if it is shown that disease is in the communicable form and it is not necessary that it should have been communicated to the petitioner, even if it is done innocently. The seventh ground of divorce is renunciation. A person renouncing the world when he ceases to take any interest in the worldly affairs or ceases to take any interest in cohabitation. In this case, the party would renunciate the world is considered as civilly dead. It is typically a Hindu practice and considered as a valid ground for divorce. And here comes the last ground of divorce, that is the presumption of death. Under the act, a person is presumed to be dead if he or she has not been heard as of being alive for a period of at least 7 years. This is a presumption of universal acceptance, as it aids proof in the cases where it would be extremely difficult if not possible to prove the fact. Decree of divorce granted under this clause is valid and effective even if it subsequently transfers that the respondent was in fact alive at the time when the decree was passed. So these are the grounds of divorce under section 13 clause 1. These grounds are available for both husband and wife. Now we proceed with section 13 clause 2, which provides separate grounds of divorce by way of a protective discrimination in favor of wife. So the first ground is bigamy. Bigamy is where the husband has more than one wife living with him after the commencement of this act. A wife may present a petition for divorce under clause 1 of subsection 2 of section 13 of the act. Only limitation on the right of a wife who applies for divorce under this provision is that the other wife should be alive at the time of presentation of petition, irrespective of the findings that the petition was aware of existence of the other wife and that the husband was not guilty of cruelty. The second ground is rape, sodomy, or we can say it as a bestiality. Under section 13 clause 2 and subclause 2 of the act, a wife is entitled to file a petition for divorce on the ground of rape, sodomy, or bestiality committed on her by her husband. Rape is also a criminal offence and is defined in the section 375 of Indian Penal Code. If the husband forces sexual intercourse on his wife, he would be guilty of rape and wife can sue him for the divorce. But the charge of rape is possible only when the parties are living separately under an agreement or under the decree of the court, that is the judicial separation. The third ground is the order or the decree awarding maintenance, where a decree for maintenance of wife under section 18 of Hindu Adoption and Maintenance Act 1956 or an order for the maintenance of wife under section 125 CRPC 1973 has been passed against the husband, the wife is entitled to present a petition for divorce provided two conditions are satisfied. The first, that she was living apart, and the second condition, since the passing of such a decree or order, the cohabitation between her and her husband has not been resumed at least 1 year. And the fourth and the last ground under section 13 clause 2 is repudiation of marriage. Under this ground, wife is entitled to present a petition for divorce if her marriage was solemnized before her attainment of age of 15 years provided she has repudiated the marriage after attaining the age of 15 years, but before attaining the age of 18 years. But the petition may be presented after completing 18 years of age. This is all about section 13 clause 2. I hope till now you are clear with both the divorce provisions. Let's proceed with section 13b, that is divorce by mutual consent. Under section 13b of the Hindu Marriage Act 1955, the parties can seek divorce by the mutual consent by filing a joint decree petition before the court. Mutual consent means both the parties agree for a peaceful separation. Mutual consent divorce is a simple way of coming out of marriage and dissolve it legally. There are two aspects on which husband and wife have to reach consensus. One is that the alimony or maintenance issues. As per the law, there is no minimum or maximum limit of maintenance. It could be any figure or no figure. Next important consideration is the child custody. This can be worked out effectively between the parties. Child custody in a mutual consent divorce can be shared or joint or exclusive depending upon the understanding of the spouses. Under the mutual consent, parties are the sole authorities to decide their fate. The court has nothing to do with that until there is consensus. However, if any point in time discrepancy arises between the parties regarding anything such as an amount of alimony or maintenance, or regarding child custody, or even one spouse changes mood not to give his or her consent, in this case the joint petition of divorce will be dismissed. However, if one party is still seeking divorce, may file a fresh divorce petition under section 13 clause 1 of the Act as one party divorce petition. So this is all about section 13 clause 1, section 13 clause 2, section 13a and section 13b. I hope you're crystal clear with all the provisions of divorce proceedings with the theories of divorce. See you in the next video where I'll be discussing section 14 and 15. However, if you have any question or queries regarding the same, you may comment in the comment box below. Thank you.